All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated. Good morning. Welcome. Court officer, can you please call the case?
Good morning, Your Honors. This is the file number KCBC 2020-04, the Specialist Prosecutor versus Peter Shala. Thank you, Your Honors.
Thank you. Mr. Prosecutor, I would like to know who's present today in court. I see a slight change in composition.
Yes, good morning, Your Honors. Good morning, everyone else. This morning we have Mr. Max Caracol with us, who's one of our legal interns. The rest of the team remains the same.
Very well, thank you. Victims' counsel, I see that you are in the same composition as yesterday. Very well. Defense counsel.
Thank you very much, Johanna. We are here with Mr. Shala, for one time with us in the courtroom. We have the same composition of the team, excepting Miss Annie Lagueux, a legal advisor, who is with us this morning. Thank you very much.
Thank you. Mr. Shala, welcome. On Monday and Tuesday, we have heard the closing statements of the Specialist Prosecutor's Office, of Victims' Counsel. Partly we heard the closing statements of the defense. There is still a part remaining. It is my understanding, Defense Counsel, that you would need the first session of this morning for finalizing your closing statements. If there are any changes time-wise, please let the panel know. And if not, then I give you now the floor.
So thank you very much. I have the feeling we will respect the timeline we provided yesterday. And with your authorization, I provide the floor. I give the floor to Mrs. Carriolo. Thank you very much.
You have the floor.
Good morning, Your Honors. Good morning, everyone. I will begin today with where we were left yesterday, with count 4 of the indictment, under which Mr. Shala is being charged with murder as a member of a joint criminal enterprise intending to kill, or participating in a joint criminal enterprise knowing that murder could follow and willingly accepting that risk, or indeed as an aider or abettor. I would like to address 3 points before discussing the prosecution's charges based on the doctrine of a JC and the evidence presented in that respect. First, Now, the defense does not take any position as to the adequacy of the medical treatment given. What needs to be stressed is that the accused was in no position to provide, to authorize, to instruct, or allow the provision of medical assistance to any person present at the Cook's Metal Factory. In these circumstances, he cannot be held liable for the death of a person there due to the provision of inappropriate or insufficient medical care. In any event, witness 1 made no allegation implicating the accused in the alleged decision to decline offering the victim with medical treatment. Now, the prosecution charged Mr. Shala with murder, relying on two forms of liability under the doctrine of joint criminal enterprise, the first and the third. As we know, the principle of legality applies not only to criminal offences, but also to forms of liability. I refer the panel by way of an example to the ICTY Milutinovic decision on Orjanic's motion challenging jurisdiction dated 22 March 2006, paragraph 15. The 1977 criminal code that applied in Kosovo in 1999 did not provide for liability through participation in a joint criminal enterprise. Article 22 of the Criminal Code provided for liability for co-perpetrators who clearly intended the criminal act. That is the classic notion of co-perpetration. Article 26 of the Criminal Code of 1977, concerning the creation or use of criminal associations for the purpose of committing criminal acts, makes no reference to the so-called foreseeability standard. The case law of the Kosovo Court of Appeals has confirmed in its judgments, in the case of JD and others, as well as XHK, that JCE, and I quote, was not one of the modes of criminal liability set in any of the applicable codes. It is our submission that the criminal law in Kosovo did not include liability under any form of a joint criminal enterprise. Not only was joint criminal enterprise not included in the SFRY criminal code, it was also specifically excluded from the law of the Kosovo Specialist Chambers. It is our submission that stretching the language of Article 16(1)(a) of the Kosovo Specialist Chambers law to include liability under a JCE would be to the detriment of the accused and in breach of the principle of legality. In addition, as said in paragraph 267 to 271 of our final brief, it is our position that JCE in general, and specifically JCE 3, were not established in customary international law in 1999 and thus could not generate liability for offences committed at that time. As we noted in our brief, the Tadic appeal judgment, which is commonly considered as the foundation of JCE liability in customary international law, was only issued on the 15th of July of 1999. The time span of the alleged JCE we have in our indictment starts on the 17th of May 1999 and finishes on the 5th of June of 1999. That is, it preceded the delivery of the Tadic appeal judgment. Criminal law must be accessible and foreseeable so that an accused can know what acts will amount to crimes. This is clearly not the case here. Mr. Shala could not have anticipated that he would be accused of any crime he did not intend on the basis of a judicially constructed notion of customary international law, which would be retrospectively considered part of Kosovo law 20 years later. the small number of post-World War II cases on which this notion was relied upon were clearly not accessible to him, were issued in a language he could not understand nor read, and in any event were inconclusive as to the precise scope of this form of liability. Apart from the serious problem with charging Mr. Shala on the basis of a JC, the prosecution has failed to show that a plurality of persons acted in concert to achieve the purpose of killing detainees at the Cook's metal factory. Nor such can purpose be inferred from the evidence we've heard. Several witnesses provided evidence that any beatings of detainees at the Cook's metal factory had stopped by the 5th of June, the day that the person identified in the indictment died. After that date, according to the prosecution's evidence always, a new officer was put in charge of the detainees, and these new officers apparently ensured, in the words of witness 1, better conditions, and with his arrival, any ill treatment ceased. Similarly, witness 1448 stated, and I quote, "The usual beating stopped after the 5th of June." Witness 1448 also stated that Chemsid Krasniqi played a significant role in the immediate improvement of the detention conditions. Witness 1448 also stated that after the victim's death, Chemsid Krasniqi, and I quote, was nervous and was using bad words against the KLA soldiers. He repeated that this is not going to happen again here. This evidence is supported by witness 4, who stated that new professional guards arrived immediately after the death of the one detainee and that they improved the conditions of detention. Thus, the evidence presented suggests that after the death of the detainee in question, measures were taken by those in charge, including Krasniqi, to ensure that the detainees were treated humanely. They changed the persons responsible for the detainees. There was an immediate improvement of conditions of detention. And this was all to ensure, in the words of Krasniqi, that this is not going to happen again here. Your Honours, how is this consistent with a common purpose to kill detainees? This evidence directly contradicts the prosecution's allegation that the group in charge of the detainees at Cook's, and Mr. Shala was never a member of such group, shared the intent to kill them. In fact, this evidence demonstrates that the persons in charge did not want to kill any detainee. They regretted what had happened. They immediately took measures to ensure that this would not happen again. The evidence relied upon by the prosecution also suggests that whatever medical treatment was available, that was provided to the individual concerned. This also goes to show that the said group did not want to kill him or let him die. Importantly, those in charge of the detainees and those who allegedly mistreated the two victims were not different persons. This is not a case where the commandants find out that inferiors acted unlawfully and immediately took steps to take care that this doesn't happen again. The person in command, according to witness 1, at least according to the most recent version of his story, is actually the person who allegedly shot the victim. Lastly, no evidence was presented which demonstrates that the accused himself wanted to kill this particular detainee. On the contrary, the accused was not aware of and had no role in the murder. He was only informed of his death long after the end of the war. Your Honours, no evidence was presented showing that the death of the said individual was foreseeable to the accused. As found in the Getty trial, This death did not follow the type of ill treatment that detainees from the use and any possible reliance on the statements made by Mr. Shala in conditions which violated his right to effective legal assistance and not to incriminate himself. I will then turn to the fundamental unfairness caused in this case by the unique circumstances in the 08 case. And finally, I will refer to the violation of Mr. Shala's right to properly confront witnesses against him. As we have heard on Monday and yesterday, the prosecution and Victims' Counsel heavily relied on statements made by Mr. Shala in the course of 4 interviews in which he was interrogated by experienced prosecutors and investigators, including prosecutors and investigators of the SPO, without being informed of and without being provided with legal assistance either prior to being questioned or during his questioning. This concerned the interviews of the accused conducted by the Belgian Federal Police and the SPO in 2016 and 2019, as well as the 2 older interviews by the Office of the Prosecutor of the ICTY. The panel has admitted the ICTY transcripts and found the Belgian and SPO transcripts not inadmissible. For all these interviews, the accused was questioned without a lawyer being present and without being afforded the opportunity to consult with a lawyer prior to being questioned. All these interviews included questioning on highly incriminatory matters to which the accused gave answers. The defense has consistently contested the admissions of these statements, as mentioned by Mr. Gillisan yesterday. We repeatedly argued that the panel's reliance on them would render these proceedings unfair. Despite these objections, despite the acknowledgement of the Kosovo Specialist Chamber's appeals panel that Mr. Shala's right to effective legal assistance for the purposes of the 2016 interview was violated, the statements even now remain available to the panel for its deliberations. As we have seen, they play a prominent role in the prosecution's final brief and closing submissions. The appeals panel has confirmed that Mr. Shala's questioning in 2016 was in clear violation of the standards of international human rights law. The breach of Mr. Shala's rights for the purposes of this interview makes the use of incriminatory statements made in the context of the 2019 interview also impermissible and unfair. Had the 2016 interview been conducted in accordance with the law, Mr. Shala's answers in 2019 might have been substantially different, especially had he been afforded the legal representation he was entitled to. The manner in which he was informed of his rights during this interview, which was conducted in the presence of SPO officials, is shocking. Mr. Shala was literally told, and I quote, "You have been informed of your rights, which were sent to you. It's the usual blah blah." Your Honours cannot accept this flagrant lack of respect for the rights of the accused. The doctrine of the fruit of the poisonous tree, which, as we have argued in our written filings on this matter, has been endorsed by the European Court of Human Rights, precludes further use of the incriminatory statements made in the 2019 interview. This is because the 2019 statements were substantially affected by what took place in the context of the 2016 interview, which violated Mr. Shala's rights. Prosecution has failed to show that these statements were given voluntarily in the absence of oppressive conduct. Any reliance by the panel for the purposes of its judgment on statements obtained in conditions that extinguish the very essence of Mr. Shala's defense rights would render these proceedings unfair, and any finding based on such statements unsafe. There is another serious problem related to this. As said in our final brief, the clear wording of Article 46H of the law, read together with Rule 138(1) of the rules, require the panel to decide on the admissibility of evidence. This is made clear by the use of the word shall in Rule 138(1), which can be contrasted, for instance, with the use of the word may in the equivalent provision of the ICC framework. The Kosovo Specialist Chambers law and rule that we've just referred to require issuing of admissibility decisions. Just like the rules governing the procedure before the ICTY, the ICTR, the mechanism, the Special Tribunal for Lebanon, the Special Court for Sierra Leone. This is because parties have a right to have a clear understanding of the trial record by the close of the evidentiary proceedings. To this date, the defense does not know whether the panel intends to rely on these statements. The silence of the defense on this matter, as the prosecution has put it, shows the prejudice suffered. Addressing these statements was a fundamental aspect of this case, a matter that even today we don't know how the panel is intending to approach. The uncertainty as to what is on the evidentiary record violates Mr. Shala's right to know with certainty the evidence against him and have an effective opportunity to respond to it, at the very least, in his final brief and his closing submissions. Second, there is inherent unfairness and breach of the principle of equality of arms by the abuse we have witnessed of the prosecution's power in the 08 case. And, Your Honours, I would like to turn to private session to address this matter.
Thank you. Mr. Court Officer, can you bring us into private session, please?
Your Honors, we're in public session. Thank you.
Thank you. Defense counsel, you have the floor.
Thank you, Ernest. I now proceed to my last point. There have been clear infringements of Mr. Shala's right to confront witnesses against him. There is a serious issue with the fact that the evidence of two witnesses, two important witnesses, witness 2 and witness 4, who were available to testify before this panel, was admitted in writing. The defense was not allowed to confront them and test their evidence. This was not justified nor merited. It resulted in prejudice, as the defense was deprived of the opportunity to confront them with a number of contradictions in the prior statements and other evidence. In addition, the evidence of two central witnesses, witness 4733 as well as witness 1448, was admitted in writing. That is fair enough, one could say, as they are both deceased. Yet, given the importance of exercising caution when it comes to identification evidence, and the fact that for witness 4733, the description he gave of the accused is evidently flawed, while for witness 1448, he identified the accused on the basis of information provided to him by unreliable others, the prejudice resulting from the admission of their untested evidence in our submission violates Mr. Shala's right to confront important evidence against him. In order to remedy this infringement, the panel should accord little, if any, probative value to the untested evidence and not accept it on any matter which is not corroborated by independent and, importantly, reliable evidence. Instead of acknowledging the evident problem with tendering the evidence of witness 4733 or the flawed identification of the accused, the prosecution has amplified it to the greatest possible extent. It has brought no less than 4 others linked to him to repeat what he had once told them. Now, they may be convinced, these other persons may be convinced about the veracity of what witness 4733 had said. Indeed, witness 4733 may have been convinced himself. The problem remains that his identification of the accused was false. Mr. Shala is almost not black, and the defense was unable to show this by confronting witness 4733. The defense was also unable to confront the false identification conveyed through the other witnesses because they only know what they were told. It is a clear breach of fairness to present such problematic identification evidence and amplify it by presenting it not only once, but 5 times in circumstances where the defense could not even confront its essence at all. This concludes my submissions, Your Honours, and Mr. Gelisa can take now the floor to conclude our submissions. Thank you.
Thank you, Defense Counsel. Then I give the floor to Mr. Jellison.
This is the difficult moment for a defense. This is the time to draw a conclusion in the case you defend. That's always a delicate moment, and I think that more than ever it is important to be precise and avoid any mistake or misunderstandings. I have to say that when I'm hearing the prosecutor presentation and arguments, I'm afraid that it could exist some tiny difficulties. And the first one, indeed, that the issue at the heart of this legal proceeding, it's not whether people were deprived of their liberty. Nobody contests that. It's not if some treatment had been imposed on some person. No, the question at the very heart of this trial concern, as Mr. Awini told you, is Mr. Peter Shala. And so we have to insist that the question is whether he participated or not in a criminal way or another in this arrest and detention, and in the condition in which this detention took place. Mr. Shala is very clear about that. No, never, not even once, did he participate in the illegal treatment and violence inflicted to the detainees. No, never. And finally, the question is whether he is guilty of the murder of one of the detainees. Absolutely not. So, could be a simple case, as the prosecutor announced it. So was Mr. Shala part of a system developed to commit such crimes? Did he himself committed the crimes that the prosecutor is accusing him of, or any of? No, he did not. Very clear. And if you were to find otherwise, he had committed one criminal offense. Has he done so as a perpetrator or in quality of accomplice? And finally, if you want to turn out that Mr. Peter Shala has committed an act contrary to the law, it would be necessary to know whether this offense was linked to crimes committed by others or whether it was specific to him and purely individual. As you know, Your Honours, all form of criminal participation requires at least one thing to be knowledge of a criminal situation. And if, and only if, the knowledge is proven to be the case, then it is necessary to establish the existence of at least one material act characterizing the situation of this person to participate in the known criminal situation. In order to link Mr. Peter Shala to the crime by those who had already been recognized guilty for the crimes committed in Cook's Metal Factory during the time of the indictment, the prosecutor relies on the statement of some witnesses who claim that Peter Shala was part in the abuses and crimes committed on the detainees. The prosecutor was fully confident with three of these persons, and only three of these persons, and built his prosecution plan on the basis of some of the statements of this person, at the exclusion of other statements issued, provided, given by these three famous witnesses. Because these other part of the statement didn't match with this plan. So I use the word, I think so, pecking and cherry. This is really what is the situation, indeed. So we must remember that on the basis of some statement of these three persons, in order to establish this necessary link between Peter Shala and the detainees, Mr. Peter Shala was presented as a person with responsibilities in Cook's. He was said to have been one of the main leaders and important person among the soldiers present in Cook's Metal Factory. He was presented as being an important member of the 128th Brigade, where he was Rujdi Salamati associate. And on the basis of a single statement, which has never been confirmed one way or another, it was claimed that his authority on the spot was such that he was freely leave or enter in Cook's metal factory without having justified his movement to anyone. 1,000 people were in Cook's metal factory. Only these people affirm, say, we don't know why, this kind of information. Of course, this kind of information has never been corroborated by someone. It was very clear Mr. Shala was stationed in Cook's metal factory, where, as well as exercising his authority on the soldier or part of them, he regularly took part in violent interrogation and crime scene involving the detainees. You will recall that the prosecutor claimed that Peter Shala had attacked witness 1 no less than 12 occasions. The reference transcript, 6th of June, 2023, page 1933. 12 occasions, please. And the prosecutor has confidence in the witness who supports his case and proceeds presentation of the fact because over several years it was the presentation and the statement of this witness. That was the situation. But we know today, my honors, we know today that the reality was never that. Never. All of us, we know it. And that's why the prosecutor changed the presentation of the case. Shala, Mr. Peter Shala was never the Rouge Aromati partners in the 128th Brigade. We know it today. He never even belonged to this brigade. Never. Shala, Mr. Peter Shala, has never had any responsibility or authorities over someone in Cook's metal factory. At no time has the slightest proof of any of this ever been produced in. Just nothing. Today, indeed, nobody continued to defend this scenario anymore, and there is even a definitive desire to forget that anyone has ever claimed that. Indeed, fortunately, the defense was able to establish that while Peter Shala was never a member of the 128th Brigade, but it also established that very, very few people of the thousands of people who were in Cook's metal factory in the first half of 1999 saw Peter Shala in this factory in the time of the indictment. And the few who saw him in Cook's metal factory at this moment, they confirm they saw him just some 2, 3, 4, 5 times maximum, and nobody said they saw him in the detention rooms or close to the detention room. I'm waiting for the name or the number of a witness who says that. No one. Absolutely no one. What's more, no one now claims that Peter Shala ever had any responsibility or hierarchical power at Cook's metal factory over anyone, and nobody claims any longer he was stationed, even stationed in Cook's metal factory or in Cook's town. Moreover, it is now clear that apart the same 3 witnesses who accused Mr. Shala of having committed crimes, none of the other 18 people that the prosecutor claims they were detained in Cook's metal factory have never recognized Peter Shala as one of the crime perpetrators, Mr. Awini was very clear about that. Or even one of the person they saw during their detention. Nobody provided us a description of a person who looked like Mr. Peter Shala. So that's very strange, of course, if we have to try to understand exactly what is the prosecution plan. The witness, the direct witness, the eyes witnesses, are very sure they didn't recognize Mr. Shala, they didn't know him, they even never heard the name or the nickname Shala or Ushku. So, nothing or almost nothing remained of the prosecutor's initial scenario apart from a whole new story
Your Honors, we are in public session. Thank you.
Thank you. Defense counsel, you have the floor.
Thank you very much. So I told you a new story. A new story issued by the prosecution team against Mr. Shala, but a new story that has constantly continued to evolve and change. Change in the statement provided by this witness to include new discoveries and information made during the course of the ongoing investigation. Take care about that. You have to take a look at the date. You have a new element by the expert report, and the statement of this witness changed. You have a new element by another witness, and the statement of this witness changed. Take a look at the date. That's sure. With the number of shots, with the number of bullets, with the position of a lot of things change. And so, as a result, we have several versions of the events and several versions of the same events with varied degrees of detail, as by example, to who was involved and what happens were used in the scene of shooting concerning the murder charge. And you know even the name of the shooter. I told you yesterday, I know, I don't have to repeat things, but sometimes we have to repeat to avoid to commit an error. Even the names of the shooter changed not once, not two, 3 times. We have 4 names of shooter. As a result, we have several versions of the same event, I say, and I have to ask the question, who was present during this scene? It changed a lot. It changed a lot. So it's not only the only time this witness has changed it, but it's not also, and could be better to say, it's not in public, but in private.
Thank you. Mr. Court Officer, can you bring us into private session, please?
Your Honors, we're in public session. Thank you.
Thank you. Defense counsel, you have the floor.
Thank you very much. I think this house man who should be the improbable witness 01, so much did he change and vary, became the incredible witness number 1. So much did the explanation for his variation become incredible. And indeed, when this witness has to explain or justify so many variation, changes, contradiction, he made a raw statement, witness 01 did it. No hesitation to question competence of some translators, of course. To question the correctness of some investigators, of course. And even to question the honesty of a prosecutor. I told you, I think yesterday, the point. This is a very important point, I think so. Because if there is some tricky thing in the procedure, of course, we have all of us to be aware about that. That's amazing that the prosecutor didn't ask why my own witness says that about one of my colleagues. And you don't ask, why did you say that? What is the problem? On the oath, my own witness says that, and no, it's not a problem. Keep silence, please. We pass through, and as soon as possible we change of subject. But just imagine, Your Honor, for a moment, what you, Your Honors, judge of Mr. Shala, would think if Mr. Shala chose to testify on the oath and vary his testimony, as much as witness 01 did. If he changed the content of his statement several times in this testimony he made before you. What is the content of his statement? Has changed, and when new information comes to light, the investigation in contradiction with the previous statement he gave before. But it doesn't end there. I told you the same witness lied. What would you think and conclude should it appear that Mr. Shala lied even one time in his explanation or statement? That sure you would declare him incredible, that sure, untrustworthy and unreliable, and you would declare you could not accept and have regard to his explanation, and of course, you would convict him. That's sure. And may I say, it would be normal. What I am asking, and what the law and justice, real justice, demand, is that the criteria used to analyze the credibility and the reliability of statement be the same for everyone. Be the same for everyone, whether the statement were made by the accused or a witness. I would add that I have no doubt it will be the case during your deliberation, because it is on the application and strict compliance with the rules that the credibility and the fairness of the procedure depends. So, I don't want to be too long. I know that lawyers, and particularly defenders, are too long, always. That's because they fear to forget something. So, as conclusion, I ask you to declare that the threshold of the legal standard of proof, beyond reasonable doubt, has not been met in this case concerning all charges against the accused, and as a result, I claim that Mr. Peter Shala must be acquitted. Thank you very much for hearing me. Thank you.
Thank you, Defense Counsel. We have now completed the closing statements by the defense, and we will now hear the responses to the points made by the defense in the closing statements by first the Specialist Prosecutor's Office, if any, and then the Victims' Counsel. Before I turn to you, Mr. Prosecutor, I have a small question for the defense, more in terms of housekeeping of the transcript. And that is not for now, but for during the break. On page 28, starting line 23 till page 29, line 3, I think that 2 words were not transcribed. And for completeness, if you could have a look at that, then you fill us in later.
For sure, Your Honor. Thank you.
Thank you. Specialist Prosecutor, do you need time to further prepare the points that have been shared in the closing statements by the defense? Or can you take the floor now?
Your Honors, if we could take the break now, that could help us just organize the references to the transcript with regard to the submissions made today.
Yes, very well. Mr. Prosecutor, then we will proceed as such. We will have a break now till 11:15, and then we proceed with the responses. Very well. Then the hearing is adjourned.
All rise. All rise.
Please be seated. Welcome back. Let me see. I see that the Specialist Prosecutor's Office is in the same composition. Is that right? I see a confirmation. Of course, the same composition. And here you are also in the same composition. And Mr. Shala is also in the courtroom. Very well. Then we will continue with the response by the Specialist Prosecutor's Office to the points raised by the defense in its closing statements. Do you have an estimation, Mr. Prosecutor, how much time you will be needing?
My best estimate would be about 20 minutes,
Okay, very well. Just to see.
give or take.
Thank you. Yes, yes. Just to see if it was within the allocated 45 minutes in principle. That you would-
Definitely, Your Honor.
Very well. Good. Then you have the floor, Mr. Prosecutor.
Your Honors, our preliminary remark before addressing specific elements of the defense submissions, it was at times not easy to understand the source of certain defense submissions. Specifically, it was difficult to distinguish whether they were based on evidence that is on record and available to Your Honors for deliberations, or on documents which were disclosed but not tendered by the parties. At this time of the trial, Your Honors, evidentiary submissions are closed, and so Your Honors' deliberations will be based on the evidence that's been tendered and considered available for deliberations. By way of example, yesterday there was a page 4258 in relation to trial witness 1, certain statements about that this witness purportedly made concerning throwing bodies into a lake. There are others. This is just an example. We weren't able to find his testimony in this regard in his trial testimony. We were able to find this reference in previous documents, but Your Honors, this is not in evidence, and there are several other remarks which we suspect are based on documents which have not been tendered by the defense and are by now not part of the trial record. So Your Honors will, of course, exercise due caution during your deliberations, but we felt we had to point this out. The defense also re-argued a number of issues in relation to arbitrary detention, the customary nature of JCE, or the accused statements, for that matter, that have been litigated before the pretrial judge, before Your Honors, upheld on appeal. So we won't repeat. We don't feel there's the need to reply on those. These matters have been settled. The defense made, they repeated and made additional submissions with regard to the credibility of the prosecution witnesses, especially trial witness 1 and 4733. I will just address some of these for now. Yesterday, the defense, I think it starts at page 4248 of their submissions, made the case that 4733 did not know the accused, and therefore he could not identify him. The basis for 4733 identification is set out in our brief in detail, and we have supplemented these submissions in our closing statements. But what, again, Your Honors, perhaps in this case, what I want to point out again is that Your Honors should have, if there is the holistic consideration of the evidence on record, that can leave no doubt about 4733 identification of the accused's presence during his transport and in the night of 20 May 1999. The starting point of your assessment should be the multiple witnesses placed him there at that time doing exactly the same thing. I mean, what are the odds? The accused himself, and as we stated in our brief, provides a lot of detail that corroborate this witness evidence. The defense haven't engaged with those, but we have explained why this witness, this evidence, is corroborated by him too. So really, what are the odds of all this just happening by coincidence? I mean, one of these witnesses, Your Honor, was trial witness 1, who made the same identification the same night in the same room as for 733. Trial witness 1 knew the accused very well. Are they both wrong? Did they both come up with the same story? Now, just to dissipate any doubt that there may be that there was some sort of communication between these two witnesses after the fact, in 2002, 4733 identified Peter Shala, Wolf, as one of the perpetrators of that night. He's the first person he mentions in that statement when he's asked to provide a list. By then, 4733 had never seen trial witness 1 after the events in Kukas. We know this because when he's interviewed again by the ICDY in 2003, and he's asked if he has any additional information about these people, 4733 about trial witness 1, 4733 says, no, I don't. I thought that maybe they were both executed. Maybe he was executed, I don't know. It shows that he had never seen him since then. There can be no suggestion, nor even a fleeting thought that there had been some meeting in which the circumstances were agreed upon. Therefore, there can be no doubt that these witnesses were truthful in describing the same event, placing the same persons there, the same date, the same location. In relation to 733 statements, but also in relation to 1448, the defense made some remarks at page 4229 of the transcript that the ICDY didn't consider them credible. They did not provide a reference that the panel could verify. We weren't able to find any. We suggest that there's such finding was never made. To the extent that the defense may refer to the fact that Mr. Shala was not indicted by the ICDY, that is a matter of prosecutorial discretion, which is far from proving that was based on an assessment of the credibility of these witnesses by the then ICDY prosecutor. Ernest, we now come to trial witness 1, and I will need to go into private session to make my submissions.
Thank you, Mr. Prosecutor. Mr. Court Officer, can you bring us into private session, please?
Your Honors, we're in public session. Thank you.
Thank you, Mr. Court Officer. You have the floor, Mr. Prosecutor.
Your Honors, the defense did not completely decline to comment or take a position on the statements of the accused. They did rely on them a little bit, but they offered a selective and decontextualized reading of these statements. Yesterday, page 4254, the defense assertively stated that the accused only learned about the murder victim's death during his 2016 interview. Your Honor, that's not true. It isn't true. They said he learned that in the course of that investigation. It's not true. What he stated in his 2016 interview is that he learned about it a few years earlier, 3 or 4. So why would he lie about that? Why? Why did he lie so blatantly about such an important detail? Why would he not tell the truth about that? This is a question that Your Honors should ask yourself, but it also shows that the defense submissions when it comes to the accused statements are selective and should be taken for what they are. Now, another sort of selective interpretation of these statements is their position repeated yesterday at page 4254 that the accused only met trial witness 1 in the courtyard of the factory. That was the only time. Your Honors, we have set out in our brief all the elements that prove otherwise, beyond reasonable doubt. But I'd like to point out to just one other detail that Your Honors may want to consider in assessing that evidence. In paragraph 146 of our brief, we pointed out evidence that during the night of 20 May 1999, one of the female victims in this case was forced to make accusations against trial witness 1, to say that he was a collaborator. And this happened inside the office room where the 20 May 1999 incident took place. Well, we invite you to look at what the accused stated in 2016, and the RN is 0741117 to 0741129, ET revised 1, page 074126. The accused on that occasion told the investigators how an 18-year-old woman who was with them made accusations against them, which included a certain person who is someone that the defense suggests trial witness 1 was collaborating with. These suggestions can be found on the transcript on the 2nd of June 2023, pages 1849 to 1850. Now, this is just another piece of evidence which tells Your Honors that he was in that room that night. He saw what happened, he heard what happened, and he recalled details about it. Your Honors, I will conclude my submissions but to respond to something that the defense said at page 8 of today's provisional transcript. It concerns the foreseeability of the murder. Your Honors, we made it clear what our position is about the murder intent. There was intent. We have set out the reasons in our brief. We have repeated our submissions and supplemented them during our closing statements. But I want to make it clear that in addition to that, it is our position that as early as 20 May 1999, that somebody could have died, that the murder victim could have died, it was a concrete and foreseeable possibility, including to the accused, with all the information he had at his disposal. Your Honors, there were guns. At least three people had unholstered guns in their hands, using them to bash heads open. Knives, blood aplenty. People losing consciousness, and alcohol. Now, something could have gone wrong in a situation like that. It's not an implausibly remote scenario. It's a concrete possibility, foreseeable to all those present in that room. In this regard, Your Honors, any different finding from previous judicial bodies are not binding on Your Honors, and you should make the decision that, according to you, is based on the evidence presented in this trial. And we submit the evidence presented in this trial leaves no doubt to the fact that it was foreseeable that somebody could have died, that the murder victim could have died, and that the accused, in spite of that, in spite of all that, continued to engage in that conduct that night, throughout the night, against multiple victims, one after the other, and again on the 3rd or 4th of June 1999. That's why, in addition to intent, the prosecution has proven beyond reasonable doubt, there is no doubt that the murder was foreseeable. This concludes my submissions, Your Honors.
Thank you, Mr. Prosecutor. Now that we have concluded the response by the Specialist Prosecutor's Office, I turn to Victims' Counsel. Victims' Counsel, do you have a response?
Yes, please, Your Honor, I do.
Very well. And for planning purposes, will you remain within the 45 minutes allocated?
I think I'm going to be 5 minutes or so.
Okay, very well. Victims' Counsel, you have the floor.
Thank you. Well, we would wish to align ourselves with the submissions that have just been made by the SPO, and we're certainly not going to repeat them. The only matter that I want to address relates to witness 1 and to the criticisms that are made of him and of his credibility. And to do that, Your Honour, I'm going to need to ask for the court to move into private session.
Thank you, Victims' Counsel. Mr. Court Officer, could you please bring us into private session?
Your Honors, we are in public session. Thank you.
Thank you, Mr. Court Officer. We are now giving the floor to the Defense Counsel for his comments on the response from the Specialist Prosecutor's Office and Victims' Counsel. You have the floor.
Thank you, Your Honor. So to briefly respond on the number of points that we just noted from the responses from our colleagues in the SPO and later from Victims' Counsel, I'll take them in turn, Your Honors. The first one I understand is the inquiry about references or indications on elements that are not in evidence, admitted in evidence or available proper. The basic answer is yes, but there is a more complex response to this. They are probably not admitted per se as evidence, but they are part of the case file. And I give you an example, Your Honors. You may agree or not with it. When we refer to the lake, Your Honor, yes, it was in a statement, and yes, that statement is not admitted as documentary evidence in the case, but it is part of the case file in our submission and the history of this procedure. Why? Because those are the statements that the SPO requested, Your Honors, to admit under Rule 154. They are part of their case. And those are one of the reasons that Your Honors refused to admit those statements because of number of contradictions and issues that warranted that this witness gives a full testimony live. It is to be taken into account. It is part of what we lived, why we heard some witnesses and why not for some others. It is part of the history, and more importantly, it is not wrong. It is not false. What we said was correct, Your Honors. The other example is the defense witness number 5. Now, mindful we're in open session. The basis for what we said is in filing 00680. The one for the previous statements is filing 465. But for the defense witness, it is filing 00680, where you find the exact elements, which are not evidence because they were not done at the time the source of this information was in the stand, but later on. But this is something Your Honors can take into account because it is in our papers, it is in the case file, it has come across your eyes and in your filings, official filings, at one point or another. We cannot make just simple abstraction of everything that surrounded this procedure. And I'll come to that point on a later point. And I know we disagree. And Your Honors have heard submissions far east and far west. We disagree, and we agree to disagree. This is our position, Your Honors. On the reproach, the second point, reproach that we revisit and resubmit some of our legal arguments. Your Honors, the answer is simple. We have to exhaust all domestic remedies. Maybe for our colleagues, this might be the end of their intervention in this procedure, but we don't know, potentially for us, the procedure is still long, and we have to make every argument we believe that is necessary to be put in any form of record through filing in the transcript. Some of the elements are addressed for the first time orally, and it is our right and our duty to expose them again. And we might disagree, but this is our position, Your Honor. Turn to the third point, which I believe concerns the witness 4733 and the invitation by the SPO to take the evidence holistically. We invite you to do the same, Your Honors, as well. But what we disagree with the SPO on is their reference to odds and coincidence. This is not the standard, Your Honors. The odds of having a coincidence. No. Our position is clear, Your Honors. Certain names were heard and were shared, And it's easy for anyone who spends time in the Cook's Metal Factory to use this name. This is our issue. And so what is the odds is not the standard to prove criminal offenses and criminal conduct. It is proof beyond reasonable doubt. What are the odds that someone also named Jakub Krasniqi be a doctor bandaging the heads of people? That is the same source that said that. Daud Haradinaj never set a foot in Albania during the war. He was mentioned to be there. Our issue is with the names. Our issue is not with the pain of the victims. We acknowledge that time after time. But who do you put there? Mr. Bardil Mamouti was here. He provided his passport with the stamps. We went through them. This is not the problem. They suffered. Okay, we're sorry for that. Not sorry because we're responsible for that. We're sorry for their pain. But we have to deliver now a verdict on Piotr Shala and whether somebody who names him and say he is black is right or wrong on that. It's not because we are here in The Hague that Mr. Shala has to pay for it. Regarding the fourth point, Your Honor, on two witnesses and their statements in 2002, 2003 at the ICTY. Yes, it is not in the evidence, Your Honor. It is a deduction that Mr. Gillissen drew from the fact that those witnesses were heard by the professional investigators of ICTY at that time, people who were specifically dealing with the Kosovo part at the ICTY time, and that no investigations. This is the context in which Mr. Gillissen made those submissions. For years, nothing happened. For years, several years, nothing happened. No investigation, not taken seriously. The next time we hear about these witnesses was, like Mr. Gillissen said, when there was a press media campaign sourced in Kosovo, but sourced in Serbia, sorry. Well, we know the names, Michael Montgomery, Jovo Martinic, those people made articles, and all of a sudden, things started to happen again. On which topic? The Yellow House, the organ trafficking. And we have documents, maybe I don't have the reference right now, where these two same people were mentioned as sources of the organ trafficking. It's a reasonable deduction. Your Honors may agree with it or not. The SPO may agree with it or not. We suspect not. But it is our position, Your
Your Honors, we're in public session. Thank you.
You have the floor.
Thank you, Your Honor. The statements of the accused, again, the point is not the point that we made. We did not refer to the statements when we said that Mr. Shala learned about it in 2016, the death. It was the position, it was our instruction. We never referred at any time because we are at odds with these statements in the way that they are used and the procedural way in which they are used. And they are precisely taken out of context. We are not taking it out of context. We are not selective about it. And what my learned friend from the prosecution said does not contradict. Years later, yes, 2016 is years later, but this is the only trace we have of it, is during those investigations. So it is inaccurate to say that this is a lie. This is our position. You might find some facts that are compatible with that, and that's precisely because Mr. Shala didn't lie. He didn't have the privilege of having a lawyer tell him before being interviewed, be careful, this is serious. So he doesn't talk like in a cafe or doesn't take something serious, that he's warned what is a suspect, what it means, what are the legal consequences of that. So he's precise when he says, if I had caught him a year ago, yes, he was confronting police all the time. He was confronting paramilitary all the time in 1998 during the war. They kill him or he kills them. That was war. If a suspect has the privilege of knowing the legal consequences of each single word, we wouldn't be in a situation where some parts of written documents are taken out of context. That is the situation, Your Honors. And Mr. Shala didn't lie. We submitted the position on the knowledge about the death. It is not from the statements. We didn't put any reference to the statements. Let that be clear, Your Honors. Your Honors, I propose to deal with another point that is female. Don't think what I say is private, but out of abundance of caution, maybe briefly go there to private session so we take no risks.
Thank you, Defense Counsel. Mr. Court Officer, can you please bring us into private session?
Following point, and I take the opportunity that we are in private session, on the foreseeability of murder. First of all, most important, What we say, it's easier to do that. We're glad to see that there was no surprise and that the points we made were fair. Yes, everyone knows about these issues with that witness, Your Honors. We refer again to the IMO report. Our main point on this is, when you look at the IMO report, Your Honors, Pieter Shala is not mentioned. He is not mentioned. There are other points that this witness mentioned Pieter Shala in 2003. Yes. And the victim counsels attempted to use it with the witness when he was questioning him. And that was precisely at that moment, Your Honors, that this witness said this was all fabrication. it felt, not from your honors, you didn't intervene that much, but with the approaches, and many times during the arguments, as if we were put in a position to prove the innocence of Mr. Shala beyond reasonable doubt, and that the prosecution and the victims were there to raise doubt about the innocence. This is not the case. They have to prove their case beyond reasonable doubt. And we are there to show what is in the evidence. We dealt more with the heart of the evidence than they did, because we are there to say it is not proven beyond reasonable doubt. There is a reasonable doubt, and for that you should acquit, Your Honors. Thank you, Your Honors. I hand the floor back to Mr. Gilles, and I think he has some further points to develop. Thank you, Your Honors.
Thank you, Defense Counsel. Mr. Gillissen, before I give you the floor, we are now in private session. Can we go back to public session?
Absolutely, Your Honor. Yeah.
Very well. Mr. Court Officer, can you please bring us back into public session?
Your Honors, we are in public session. Thank you.
Thank you, Mr. Court Officer. Defense Counsel, you have the floor.
Thank you, Your Honor. Could be a little bit special, but I need to add some words about 28 years for the sentencing. About these 20 years. That's how required by the prosecutor. It's a lot, that's sure. But I fully understand this kind of sentence, this issue of a particular vision, a repressive one. I know it perfectly well. I was prosecutor for the UN, so I fully understand it. Of course, if some crime has been committed, we have to sentence it. That's sure. But I also know the risk that includes such a vision. Blindness, because I think blindness hides a part of the world and the complex reality. I do not wish to be derogatory. That is not the purpose of my remark. But pay attention to the fact that what people need, and particularly in the Balkans, what people need is less language of legitimate repression than a reconciliation discourse. This type of discourse is the only one that can lead to peace, and we saw it and we know it after so many years of international justice in the Balkans, with the success of the international justice and the failures of the international justice. We have to be careful. We have to be careful, you know, exemplary repression, okay, but to claim it, we should first be exemplary ourselves. When I say ourselves, I say the international community. And we know that in Kosovo, it's not a bad word to say it's not a full success. Of course, we know that a lot of perpetrators, a lot of people, executioners, well known, never been tried and never will never be tried. Never. They died in their bed in Serbia, or they are general or officer in the army, but now they are people who are aged. But for the Kosovan population, I think it's very important to understand that the people who defend them has to be punished if they committed crimes. But do you realize even a second, what is the consequences of such a war in 1999, 1988 and 1999 on the morality of a society. How much the rules of the morality for every individual in a society are weakened, destroyed, when you are obliged to be a witness, because that's not a choice. When you are obliged to witness rapes, killing, violence on the elder, on the children, on the women, the houses burning, you lose all, you pass through the borders with no document, because they deprive you with your document. Do you realize what is the effect of that? Do you realize that a man, a woman in such condition is not a little bit reduce his own identity in his own way to understand and to live the reality? When you put people in so exceptional situation, can we really be astonished that they react exceptionally? So we have to respond to this kind of question. It doesn't mean, if crime has been committed, that the people who made these crimes made nothing, or we have to understand, or we have... No. That's more than this. That's more than this. And 28 years, please, I know The Hague is a city very expensive, but the raise of the price has nothing to see with the raise of the sentences. I don't have the intent to talk about Mr. Ruju for genocide, 12 years, Mr. Katanga, with his child soldier, 12 years, or even in the ICT, why I have the choice. I have the choice. Where so many superior politicians who decided to commit the crime by a policy didn't receive 8 years. Please, that's excessive, of course. What I say, and I have the intent to insist on this, not to belong, but to insist on this. International judges in Kosovo, in Mitrovica, has to know this case. For Mr. Krasniki, 8 years. For Mr. Geci, but Mr. Geci was prosecuted on the basis of crimes committed in Chahan too. 12 years. Do we have to go to The Hague to hear such a sentence, an excessive sentence? 25 years? 28 years? And I could add some elements, but this is in our final brief, so I don't have to focus on develop that. Why to reduce a man? Why to reduce a man for what he could have made during some days, some weeks, not even some or several months? Why to reduce a life only to this? This is my vision of the criminal law. This is why I'm a lawyer. That's why I pretend to fight for justice. And it is the same if you are in the position of the prosecutor or if you are in the position of the defense. I make both. You have a certain vision of humanity, of what must be the life on planet Earth when you live in a society. So, if some crime has been committed, you have to sentence, of course. But you have to take care and to take a lot of things on board, as you say usually, on board. And I think a sentence is a message. That's always a message, or there is no reason to sentence. You don't sentence an animal, he's not able to understand. You sentence a man. Criminal law is made for men, for women. And we must apply it with humanity. And the message in a sentence, of course, is of course to punish. But it's to the person you decide to sentence, but to the society too. And I think that in this condition, which is very difficult, the condition we know in Kosovo, we need, of course, to sentence the crime which has been committed or which could have been committed. But we have to deliver a speech to open the possibility to be able to make peace. And that's why an excessive sentence is without a sense. Not too less, please, not too much. Proportionate sentence in a humanization message. Thank you very much, Your Honor.
Thank you, Defense Counsel. We have now completed the comments of the defense to the responses of the Specialist Prosecutor's Office and Victims' Counsel. I propose that we now take our break till 2 o'clock, so 1.5 hours. And then we proceed with the questions of the panel, if any, and with the closing statements on the reparations. And we see how this afternoon proceeds, where we will end at the end of this afternoon. The hearing is adjourned.
All rise. All rise.
Please be seated. Welcome back. The same composition at the side of the Specialist Prosecutor's Office, also for Victims' Counsel, and let me see also at the Defense Counsel's side.
Yeah, almost the same composition. We have the same member of the team with us.
Very well.
Thank you.
Good. Now, that is noted. Then, we have completed the comments of the defense to the response of the Specialist Prosecutor's Office and the Victims' Counsel. And because from the side of the panel there are no questions, we will proceed now with the closing statements on reparations. I will first give the floor to Victims' Counsel and then to the defense, and then there will be a possibility for response and comments. Victims' Counsel, you have the floor.
Thank you, and good afternoon to Your Honours. We've set out the many different ways in which the victims in this case have been harmed in an impact statement, and we have made a request for what we see as appropriate reparations in a separate filing. Together, those two filings run to something over 30,000 words. And in compliance with the trial powers instructions, we will not be repeating those written submissions, but instead focusing on a reply to the defence response to the reparations request, which is filing 819, and it's going to assist Your Honours to have sight of that document as I make my submissions. What we say about the response is simply that it has the law wrong. And I'm going to take you, if I may, to what we submit is the paragraph in which the legal analysis of the defence takes the wrong turn, and then explain why we say that is an incorrect position for them to have arrived at. It's paragraph 15 of the defence response, and it reads as follows. In light of the above, and citations have been made from the jurisprudence, in light of the above, as established in international jurisprudence, the accused may only be held responsible to repair any harm directly caused by a crime for which he is convicted. He cannot be held responsible to repair the harm not directly caused by a crime for which he is convicted, nor can he be expected to repair any harm caused by crimes or acts carried out by other KLA members during the relevant time period. And it's the third of those propositions we submit which is in error. So the paragraph has three propositions to make. The first is that the accused may only be held responsible to repair any harm directly caused by a crime for which he has been convicted. That, we submit, is uncontroversial. By the time the panel reaches the issue of reparations, the accused has inevitably been convicted of at least one crime. The panel will then be considering the impact of that crime on the victims, and then it will consider the appropriate reparations. So we regard this proposition as correctly stating the law, and we say there is no scope for, nor any need for, further explanation. The second proposition in paragraph 15 is that the accused cannot be held responsible to repair the harm not directly caused by a crime for which he is convicted. What we say about that is that this situation doesn't arise on the facts of this case. There is no claim for harm not caused by a crime for which the accused is not charged. However, it seems to be the case that the defence are suggesting that there needs to be a causal link between the actus reus of a crime committed by the accused personally. And this underpins the third proposition made by the defence, which is this: nor can he be expected to repair any harm caused by crimes or acts carried out by other KLA members during the relevant time period. We say that that is contrary to the law. What it is doing is putting forward a scenario which purports to be in contradiction of proposition 1, but it introduces a wholly new feature: crimes or acts by other KLA members. And we submit that the short answer to this proposition is this: it depends on whether the other members were co-perpetrators, either as those that the accused aided or abetted, or as part of a joint criminal enterprise, or otherwise. if the others were jointly involved with him, and let's stay with JCE liability for the moment, the law, we say, is crystal clear. The JCE members are all jointly and severally liable for the harm caused by their crimes. The case of Ntaganda is cited by the defence, but the citation is, with respect, a highly selective one. In fact, the trial chamber in Ntaganda came to a conclusion which is directly contrary to the proposition put forward by the defence. And if I could have, please, slide 23 from our PowerPoint. Thank you. In principle, the question of whether other individuals may also have contributed to the harm resulting from the crimes for which the person has been convicted is irrelevant to the convicted person's liability to repair that harm. Accordingly, it is not per se inappropriate to hold the person liable for the full amount necessary to repair the harm. The focus in all cases should be the extent of the harm caused by the crimes for which the person was convicted and the cost to repair such harm, rather than the person's role in the commission of the crimes and the modes of liability for which the person was convicted. Accordingly, the Chamber finds Mr. Ntaganda liable to repair the full extent of the harm caused to the direct and indirect victims of all crimes for which he was convicted, regardless of the different modes of liability relied on in the conviction, and regardless of whether others may have also contributed to the harm. As to the shared liability of Mr. Ntaganda and his co-perpetrators in the crimes for which he was convicted, including Mr. Thomas Dubanga, the Chamber notes that they are all jointly liable in solidum to repair the full extent of the harm caused to the victims. Responsibility in solidum, as noted by the appointed experts, entails the corresponding right for any of the co-perpetrators who may have repaired, in full or in part, the harms caused to the direct and indirect victims to seek to recover from the co-perpetrators their proportionate share. And for those who are listening perhaps outside the courtroom, the expression in solidum means joint and several liability. Those conclusions in those three paragraphs are, we submit very plainly, the direct opposite of the proposition that is relied upon by the defence, that he can't be expected to repair any harm caused by crimes or acts carried out by other KLA members during the relevant period. That is not what this case decides, and it's not what the appeals chamber decided either. If we could go to slide 24, please. The appeals chamber recalls that a convicted person's liability for reparations must be proportionate to the harm caused, and inter alia his or her participation in the commission of the crimes for which he or she was found guilty in the specific circumstances of the case. The appeals chamber further held that the above finding does not mean, however, that the amount of reparations for which a convicted person is held liable must reflect his or her relative responsibility for the harm in question vis-à-vis others who may also have contributed to that harm. The appeals chamber clarified that, in principle, the question of whether other individuals may also have contributed to the harm resulting from the crimes for which the person has been convicted is irrelevant to the convicted person's liability to repair that harm. While a reparations order must not exceed the overall cost to repair the harm caused, it is not per se inappropriate to hold the person liable for the full amount necessary to repair the harm. And we don't have it on a slide, but if one were to read on to paragraph 271 in the Appeals Chamber judgment, the Appeals Chamber says this: the Appeals Chamber finds that the trial chamber correctly imposed joint and several liability. In other words, endorsing the approach set out on our slide 23 of the trial chamber. In fact, and it reinforces the point, but it's not necessary for the argument, but I'll mention it as we have it to hand. The law goes further than this. In Katanga, the accused was found liable for harm that was caused by people who were not even in the joint criminal enterprise. Others took part in an attack who were not part of a JCE with the accused Katanga, and notwithstanding that, and it's paragraph 166 of the trial chamber's judgment in that case, notwithstanding that, the accused was still held liable for the full extent of the harm that had been caused. And so for those reasons we say that paragraph 15 in its third proposition leads the panel away from a correct understanding of the law, and the position is, as stated, it is simply not relevant that others in a JCE may have also caused harm. And if one stops to think about it, that's an entirely, it's a proposition of law in respect of reparations which is entirely consistent with the basis for a joint criminal enterprise itself. In a joint criminal enterprise, the actors become responsible for one another's actions and misdeeds because they're all seeking a common purpose. And so it shouldn't come as a surprise that when it comes to reparations, it's not open to an individual actor to say, well, I only caused this aspect of the harm, not that aspect of the harm. That would reduce the law to an absurdity, and that we respectfully submit is not what will happen here. That's what I want to say about the law so far as other actors is concerned. May I just add this? Paragraph 21 in the defence filing, excuse me, it is said that the acts outlined above, which allegedly resulted in witness 1 suffering physical harm, were not carried out by the accused. It has not been demonstrated that they were carried out by the accused. They may have been carried out by other KLA members at the Cookish Metal Factory whose acts and or omissions, if any, do not engage the accused's liability. Now, in part, I've already dealt with that proposition because we're dealing here with a case of joint perpetration. But so far as the proposition that the accused didn't commit any of the acts at the Cookish Metal Factory, which runs through the submissions of the defence on this topic, we respectfully submit this, that by the time the panel is considering reparations, a conviction has been entered in respect of one or more crimes. At that stage, it doesn't matter at all that the defence assert that the accused is not guilty. it doesn't matter what they say, nor what the prosecution say, nor what we say. We're beyond the point of argument. And so the much repeated submission that the accused was not guilty and didn't commit any of these acts are by this stage beside the point. Well, I'm going to deal now with the issue of material harm with regard to two of the victims in the case, and I'm afraid that I can only do that in private session.
Thank you, Victims' Counsel. Mr. Court Officer, could you please bring us into private session?
Assessment of the IMO experts. I'm going to now take you to his subjective view, in other words, what it feels like to be him. And if we could have, please, slide 26. His subjective view is equally clear about the limitations to his life, and although he wouldn't express it in these terms, he sees the world through the lens of his PTSD, and he cannot take a full part in it as a result.
Your Honors, we are in public session. Thank you.
Thank you. Victims' Counsel, you have the floor.
Thank you, Honour. The last point I want to deal with is at paragraph 16 of the defence response, where it is suggested that the amounts claimed by us relating to the harm are, quote, excessive and disproportionate. With the one exception of the medical expenses that I've just dealt with and which we don't rely on, that there is no attempt by the defence to engage with the amounts themselves. That there's no attempt to say how our approach to the figures is wrong or how the final figures are out of keeping with comparable situations. Indeed, so far as material harm is concerned, with regard to witness 1, the figure that we propose is a modest one, even against the assessment of the defence expert. It's much less than half the figure that the defence expert considers to be reasonable if there is to be an order for reparations reflecting the material harm to witness 1. And we suggest quite tellingly there is no attempt to say what the actual amounts should be. If, as the defence say, they should be lower than those claimed because they are excessive and disproportionate, then what are the right figures? We respectfully suggest it's one thing just to say they're excessive and disproportionate. What should they be and why? What basis is proposed for lower figures? We have argued our figures and we say that in particular they are in every case in line with the figures that were decided to be appropriate in the Mustafa reparations order. And so we reject the claim that they are in any way excessive or disproportionate, and we suggest that the reason why there has not been an attempt to propose alternative figures is because the amounts themselves are proportionate, justified and fair. And those are the submissions that I should like to make in respect of reparations, Your Honour. Thank you.
Thank you, Victims' Counsel. Now the moment is there to turn to the defence for its closing statements on reparations. Defence Counsel, you have the floor.
Thank you very much. I would like to have this thing to be able to work properly. Thank you very much, Your Honor. Thank you. About reparation, let us be clear once and for all. Mr. Shala's defense intends to respect the pain and suffering that people have endured. And therefore, the principle of compensation for damage suffered as a result of the commission of one or more crimes cannot be contested or called into question. That's sure. But of course, this presupposes that any form of reparation is linked to damage that is proven to have been caused by or at the time of the commission of the offence. As things stand, however, we have noted that claims are generally, not for all, but generally not accompanied by any justification whatsoever. Finally, the rare occasions when explanations are given in relation to a loss, they are unreliable or based on unjustified assumption or even improbable projection. how do you think that people coming back from concentration camp made when they will come back? I have in my family some people who were obliged to come back in Belgium after being detained in this place in Germany. And it was very difficult for them, of course. But they were obliged to come back to work. Other time, okay, but this is the reality. So that's a very difficult thing, to be obliged to manage what is the part of the damage, if there is any, and what is the choice of some people to consider that they have to stop to work. And in the situation of witness one, I saw that this incapacity to go to the work was not an incapacity to go to the cafe to shot, or to beach and to beat some people. So things are delicate. I don't say, I refuse to say there is nothing. I have to say we have to be prudent to deal with these things. I believe that we have largely developed our observation on this subject in our final brief, and that's without doubt. We can refer to it in order to avoid any repetition. However, it seemed to me that the observation and arguments set out in our final brief can be supplemented by a more general reflection that concern any reparation process in the other claim. This reflection is inspired by a fundamental principle that must never be forgotten, this delicate area of compensation for the consequences of the effect of damage over time. I'm referring to the law of entropy. This is the second principle of thermodynamics. It is a law that applies to everything, including human beings. It is very simple. Naturally, everything that is organized and composed tends to wear out, to degrade, to destroy and decompose. Entropy allows that causes everything to wear out. And there is no reason why there is or there should be compensation where they will have been lost anyway. That's the only element I would like to add to our final brief. Thank you very much for hearing me.
Thank you, Defense Counsel. I now turn to Victims Counsel. Victims Counsel, would you like to, do you have any response on the defense submissions?
Yes, I do.
Then you have the floor.
Thank you very much. Well, first of all, for most of what I said, I was concentrating on the law and whether it is correct that the accused can be held liable for the acts of his co-perpetrators in a joint criminal enterprise, and unless it's covered by the second law of thermodynamics, I don't think that I heard a response to that part of my submission, which is addressing the repeated assertion in the defence filing that the accused cannot be held liable for the acts of others. Are we to understand that the defence agree in relation to that? That would help us, because I can stop making submissions, but I've made the submissions. There's been no response to it, and that's the main reason why I wanted to say anything at all this afternoon. So I'm in difficulty replying to it because there hasn't, it seems to me, been an argument put up against it. So I'd invite the court to say, let's clarify that now. Is that just an omission, or is it agreed that the law is as I've suggested it is in relation to the liability of the accused for the acts of others in a JCE.
Thank you, Victims' Counsel. I leave it to Defense Counsel to either give a comment or not on this specific issue.
Yes, I think the best, Your Honors, is to hear Ms. Cariolo about that. Thank you.
And then we are in the comments of the defense on
thank you.
Victims' Counsel's
Yes, of course.
response.
But what I want to underline,
I'm so sorry.
my close colleague made his job, explained it perfectly well. It must be very clear about that. So no, absolutely no reproach from us. Thank you.
So I was going to say some other things too. I was going to invite the court to clarify the defence's position, but I wanted to say some other things apart from in relation to the law in reply, if I may.
You have the floor, Victims' Counsel.
Thank you very much. So far as our claim for reparations not being accompanied by any supporting arguments, can I remind the panel of the report of Dr. Lertz, which is a closely argued analysis of the position so far as material harm is concerned in relation to both witness 1 and 4733. And I'm not going to take the panel through it. You have the documents. I'm afraid we couldn't disagree more with the assertion that we haven't argued our position. We've argued it by reference to the position in Kosovo and the Supreme Court's guidance on compensation. We've argued it in relation to all of the evidence that's been put before the court, and we've argued it in relation not only to the Mustafa case, but to cases before a number of other courts and tribunals as well. So I'm afraid we can't agree with Mr. Gillessen about that. Choice to stop working. I'm not going to repeat the physical difficulties that 4733 had, nor his psychological difficulties. But it is obvious, we suggest, that it wasn't a choice of his not to work. And the same observation applies with equal force to witness 1. These are not people who have thought to themselves, well, if I just do nothing, perhaps one day I'll be compensated. There was no prospect at the time that those two men stopped their working lives of a court of this kind having the power to order reparations. And it is not through idleness that they have suffered financially. It's through being very grievously mistreated at the hands of this accused and others. And so that's the reply that I wanted to make. Thank you all.
Thank you, Victims' Counsel. There was a misunderstanding with regard to that, either whether you were finished or not.
I'm finished now. Thank you.
Very well. Now we can hear the comments of the defense to the letter.
Your Honor, thank you. Just perhaps a clarification is required. When we stated the evident fact that Mr. Shala cannot be held liable nor ordered to repair harm caused by others, we meant others who cannot be considered jointly liable. And I believe that this clarifies our position. Thank you.
Are there any more comments from the side of the defense?
Excuse me, Mr. Gillessen, just to correct something on the transcript. When Mr. Gillessen referred to our submissions on reparations in the final brief, it is actually in the response to the reparations, and I think everyone understood it. It was just a slip of a tongue. Thank you.
Thank you for that addition. defense counsel are the comments of the defense with the remark of your co-counsel, the conclusion of your comments?
Yes, I think so. Thank you very much.
Thank you. Then we are at the point of the questions from the side of the panel. I will have a short look at my colleagues. There has been a deliberation on this specific point. Thank you. Thank you very much. There are no questions from the side of the panel. And at this juncture, I want to address the accused and ask him if he confirms his position that he wants to exercise his right under Article 135, paragraph 4 of the rules to speak last. So, Mr. Shala, can you confirm that you wish to address the panel and speak last, as preferably indicated by your counsel?
Yes, Your Honor. Apologies, do I need to stand up or can I stay seated?
Now the floor, Mr. Shala.
Yes, Your Honor. I had a lot to say, but most of it was expressed by my lawyers, and I'm grateful to them for that. There are, however, a number of things that need to be said. I believe that I'll be clear. enjoyed respecting within the Albanian community my spouse and myself. My spouse, for whom I feel so sorry, because she suffered so much after this tragedy. I don't need to say it publicly here, because you know it very well. You have documents to that effect. I don't know what I have to pay and why I have to pay it. And to trust this witness when, and I can say this publicly, when he says Hashim Thaci was the driver of Peter Shala. The Minister of Defense, Azem Sula, would have been my bodyguard. I can guarantee you that Hashim Thaci doesn't even have a driver's license even today. And now we're supposed to trust this witness? I don't know. I don't have much to say. I am not a lawyer. I did not study law to express these things, to understand them. But trust the prosecutor who is proposing you and suggesting you that nothing coming from any other court proceedings should be considered, but only what I'm submitting. The prosecutor, if he were to present this evidence to some artificial intelligence, this poor evidence, the artificial intelligence system would get confused and completely confused, let alone human beings in flesh and blood like we are here. In case 6, a person testified, and this was a completely, entirely exonerating testimony, evidence for me, and we provided that to you. But now you can see what we can read in that evidence. Look at this. It's charge me with. I have absolutely no connection, absolutely no responsibility, nor did I have any knowledge. Therefore, I have 2 children who are under medical treatment. My wife is under medical treatment. My life is ruined and destroyed. And I thank you for the justice you're putting in place and the justice you're showing to the world. This is all I had to say, Your Honor. My life is in your hands. I'm not asking for mercy, but I'm asking for a fair and logical judgment. I'm not asking for mercy because I haven't done anything to ask for mercy. If a person has to be found guilty or convicted for participating in a war, then you need to bring here 16,000 Kosovo Liberation Army members. But with respect to the liability in the criminal joint enterprise, as it alleged, no. If you need to convict me because of I was member of the Kosovo Liberation Army, then yes, bring 16,000 people here. If I warn all those 16,000 Kosovo soldiers at a minimum that this can or will happen to every single one of them if this is the justice we're serving. I thank you. This is all I had to say.
Very well. Before closing this case, I turn to the parties and to the Victims' Council in order to see if there's anything you would like to raise with the parties. Mr. Prosecutor.
No, Your Honor. Thank you.
Victims' Council.
No, thank you, Your Honor.
Defense Counsel.
No, thank you, Your Honor.
Good. Thank you. In that case, I declare the case pursuant to Rule 136 of the rules closed. And according to these rules, at this stage, no submissions may be made and no evidence may be submitted unless exceptional circumstances and showing good cause exist. And this, of course, does not include any matters that need regular review, like the detention of Mr. Shala. And then, on behalf of this panel, I thank the parties and the Victims' Council for their contribution and for their assistance and their attendance since the transfer of the case to this panel. I thank the interpreters, the audiovisual booth, the stenographer, and the security, the people from CMU, and also all the people in and out the courtroom working for the registry for their invaluable assistance throughout this trial. We will issue a schedule sufficiently in advance to the issuance of the judgment, and that means that now the hearing is adjourned.
All rise.